Hello and welcome to Real Estate Today. I'm Laura Harbison, broker owner of Realty Executive Southern Nevada Properties, and I'm your host. And today we are here with Kerstan D of Essential Legal Services. And our topic today is what happens with real property when there is a divorce situation and the parties are not agreeing on what happens with that real property.
Right. This is carrying forward from some of the conversations we had in the past about co-owners and what happens when there's disputes as to ownership, manage, or use of property. But some of our ownership interests are through a marriage. They're held under and overseen by community property laws in the state of Nevada. And so most of these matters will be tended to in family court, which is different than usually the district court in which the property resides. It will be in family court because it's going to be part of the divorce or separation process or annulment process, one of the three. So basically, under community property law, there's one thing we always need to remember, and that is the definition of separate property, because everything else you're going to find is going to be deemed or presumed to be community property that is not separate property. So we ask, what is separate property? And under statute, it will tell you that all property of a spouse owned by him or her before the marriage and that was acquired by him or her afterwards by gift, bequest, devise, or descent, or by an award for personal injury, with rents, issues, and profits thereof, will be separate property. So what does that really mean? Property you had before the marriage, property you might have inherited from family members, through bequest or devise. And if you're injured in an automobile accident and you're given a settlement amount for your bodily injury, that will be your separate property too.
Oh, okay.
Everything else is community property. So obviously that opens up the door to almost anything else after the date of marriage. So you have to start to look at that. When you go into court to terminate the marriage, you will have to figure out how you want to divide up all different types of community property and just marital property in general. We're not sure what is separate or community until it's demonstrated to the court. But when the court does see community property in general, there's a very rote application under NRS 125. And that it will state that the property should be divided equally, and they will have an exception held by the court to do an unequal distribution under some circumstances, but more or less what you're going to see is just that equal distribution
Of the community property.
And individuals can get mad about that. It's interesting because it's funny how when a relationship ends, everyone feels really justified that their efforts in the marriage somehow meant more and should mean more from a monetary perspective, but it really is not the case, though it's a fairly rote application. We have a situation, though, with real property and marriages where sometimes it's unclear if it's separate or community. And that happens when we commingle our assets over time. They can be transmuted. And so what happens in a situation where you have an individual who purchased a home, their first starter home, say, young kid, and he puts his money down and he's paying his mortgage, and then 5 years later meets the love of his life, proposes marriage, and she moves in with him. They're married from that day forward. And all of their joint income is going to pay this mortgage and improve this property that is their home that they reside in. Maybe they decide to have a family there. And so back in the 1990s, our courts came up with a formula for the judges to apply in situations like that. And we call that the Malmquist formula. And so typically this occurs when you have separate property that's later used for community purposes and becomes marital property. There's the mutation that occurs. And what it will do is it will look at the original value of the home and all of the appreciation up until the date of marriage. And it will partition that out and say that's the separate property interest and appreciation. And then it will look at how much money the community, the couple, paid toward this mortgage principal over time, the number of payments, and how the home has appreciated from the time of the marriage. And that will be your community property interest.
So basically, they would get two appraisals, an appraisal based on the date of marriage and an appraisal based on the date of divorce.
Yes. Or sometimes you can just do the purchase price too for the date of purchase as being the market value. But if you want to get an appraisal, you could. So once they have those two interests, then the person with that separate property interest will be given back to the individual who originally had the property. The community property interest will be divided, one to one partner, one to the other partner. They do handle improvements a little bit differently. Our courts have opted to provide the cash value or reimbursement value for improvements to real property versus this appreciation.
Capital improvement.
It becomes a little bit difficult to say, oh, this improvement appreciated the home to this amount of monies. They don't go to that extent with the improvement.
But then if they sell that home and buy another home because of their growth, for whatever reason, they want to upsize, downsize, what have you, now would that be considered commingled?
Once they sell the home, if they don't do a formal accounting, each transaction, it becomes more and more convoluted. And remember, the person who's asserting separate property, they have the duty by clear and convincing evidence, which is a higher standard in court than the preponderance of evidence, that is their separate property. Sometimes I've seen people they have to go get a forensic accountant and go back through years and years in order to provide, that clear and convincing evidence to the court. So it is best, if you are worried and concerned about your separate property, to protect it, probably prior to marriage, but you can protect it even after marriage. It's not too late. Under NRS 123, we have our 123, we have our premarital agreements that are recognized in most courts. That's where both parties come to the table. We'll start with like the prenuptial, postnuptial, or antinuptial. They have several names. And the couple will divvy up the property. And especially the marital home gets a lot of concentration because sometimes we do have this situation where the Malmquist formula would apply. And these couples can opt out of community property law. You can have one person say, you know what, that's going to continue to stay my separate property, so on and so forth. You will get this instead, or however the parties want to agree or come to terms is fine. So it's usually this full disclosure of all your assets, all your debts. The other party comes forward, all their assets, all their debts. They discuss how they're going to handle their income, the homes that they have, the vehicles that they purchase over time. And then it is reviewed by both parties, signed and dated, preferably notarized, and preferably both parties have their own counsel looking after their own interest.
Now, could they accomplish this or part of this through the trust process, like with a family trust and a separate property trust?
So yes, you can use the trust process, the estate planning process, to deposit community property versus separate property into each. However, the family court can reach even irrevocable trust. So it's important to know that just because it's in something we call an irrevocable trust, which tends to be an asset type protection trust, the courts very much have demonstrated that they will go into one and take out community property and distribute it as needed. So I believe it's best to go ahead and do the premarital or postmarital, because you can do it after the marriage, and actually just use that document in tandem with your estate planning documents, because the premarital agreement and the postmarital agreement are your sword and shield in divorce court.
Very good. Well, that was a lot of information as well. If you have more questions about that situation, you can give Kerstan a call at Essential Legal Services. I'm Laura Harbison, broker-owner of Realty Executive Southern Nevada Properties, trying to bring you all the things you need to know about real property. So feel free to give me a call with any questions as well. I'm always around to help.